Can I begin by thanking Mr. Belayas and Erpic for the invitation to escape England and to arrive under this palm tree to give you a lecture this evening. As you can probably tell, I'm recovering from the effects of our freezing cold weather in England, and if my voice doesn't carry, can you please tell me at the back and I will raise it. I begin by declaring an interest. I am a university lecturer at the University of Hertfordshire, where I teach law, and I'm also a non-practicing member of the legal profession in England, which is under a professional duty to uphold the rule of law, the subject matter of my lecture here today. The second declaration of interest is that my paternal grandfather hails from the village of Pedra and my maternal grandfather hails from the village of Lisi, both of which are in the occupied area. So with those preliminary thoughts behind me, let me take you to a very dark and troubling place. 70 years ago. 70 years ago, the Second World War was unfolding and parts of Europe were sinking into the depths of depravity. It is a troublesome thought that exactly 70 years ago today, on the 12th of February 1940, the US magazine Time carried an assessment of the Black Guard, the official organ of the SS elite of Nazi Germany. And according to Time, exactly 70 years ago today, the Black Guard teaches young Nazi troopers to believe in the destiny of a German master race. In seeking to give his theory a scientific basis, the publisher of the organ, Heinrich Himmler, maintained a large research staff which analysed and broke down into racial groups the gallons of human blood it has collected. Himmler was exactly my age at the time. The newspaper went on to, Time magazine went on to provide an example of the nauseating dribble which corrupted the minds of the Nazis and resulted in unimaginable brutality over the next few years. If he were really a practical God who would see it that law and order prevail, he would have said to himself long since, I have made things hard for the Germans long enough. Now they will finally have some good luck. Well, we know what happened next. But during that sinister period from 1933 until 1945, Nazi Germany engaged in a series of sinister acts which are now considered to be illegal, unethical, and unacceptable. Within Germany itself, the Nazis neutralised the legal profession at the very outset of their stay in power. They co-opted the judiciary and they introduced the Nuremberg laws and other legislation which discriminated in favour of the German Aryan population and discriminated against others, especially Jews. As a consequence, Jews were not only ousted from their properties, but they were also stripped of their right to own property. Jews were detained without trial, incarcerated in concentration camps, and condemned to death. Externally, Himmler, to quote Richard Evans in his scholarly analysis of the Nazis' rise to power, Himmler, in common with Hitler, believed in the idea of war as the summit of human achievement. Nazi Germany therefore waged the crime of aggression by invading, conquering, and occupying the territory of other sovereign states. German forces committed ethnic cleansing and created Lebensraum, living space, so that the conquered territories could be colonised by Germans. Hitler established puppet regimes in the conquered territories where law and order were enforced by decree. Any dissidents who voiced any objections were arrested, tortured, or killed without due process of law. Aristotle, ladies and gentlemen, was surely right when 2,500 years ago he said that man, when perfected, is the best of animals, but when separated from law and justice, he is the worst of all. Now, we all know that eventually Hitler, Himmler, and their cronies met their fate. Europe was rebuilt, and the pillars of the rule of law were gradually erected in the form of various legal instruments, including the 1945 UN Charter, the 48 Universal Declaration of Human Rights, the 1949 Convention on Genocide, the 1950 European Convention of Human Rights, the principles of the Nuremberg Charter of 1950, the Convention for the Protection of Cultural Property, and the 1957 Treaty of Rome. All that had me thinking. British, in recent days and months in the UK, have been associated with the arguably illegal invasion of Iraq. The British Foreign Office has been pilloried for its involvement in that escapade. And it's true that Iraq, in common with Cyprus in '74 and the Suez Adventure of 1956, have cast a very dark shadow over British foreign policy in the UK. But let us not forget that those pillars of international law in the post-war period were constructed in large part thanks to the United Kingdom. And it's thanks in large part to British judges that the rule of law has been elevated to the status it now has within the European Union. That's a very important point. I can easily engage in Brit bashing. In fact, if there was an Olympic Games for Brit bashing, I think I'd have a very good chance of winning the gold medal. But that's not my job today. My job today is to explain to you the rule of law as it has been articulated primarily by British judges. And this, I believe, perhaps in common with football, whiskey, the English language, the English literature and the internet, is perhaps the greatest contribution that the United Kingdom has given to the world, the rule of law. Let me move on. The British, as we know, weren't at the forefront of the foundation of the European Union. Watch Yes Minister to find out part of the explanation why. But the Treaty of Rome of 1957, which gave rise to the European Union, was, of course, a response to what the Germans had done in Europe during the Second World War. If my technology works, there it is. That's a map drawn from the European Commission, for which I'm grateful. It's no coincidence that the six founding fathers of the European Union, the West Germany, France, Italy, Belgium, the Netherlands and Luxembourg, bore the brunt of German aggression during the Second World War. The community, as it was originally called, was established according to the Treaty of Rome to ensure the development of prosperity in accordance with the principles of the Charter of the UN, and by pooling resources to preserve and strengthen peace and liberty. This was an attempt, in large part, not just to give the French and the Germans an opportunity to control Europe in a different form, but to bury the past. The gradual expansion of the European Union over the past few decades, the evolution of EU treaty law and the negotiation of the Lisbon Treaty, which came into force in December of last year, must all be viewed against that blood-soaked wartime backdrop. It must also be viewed in accordance with the post-war subjugation of Eastern Europe by the Soviet Union and the subsequent collapse of the Iron Curtain. Today, after all, a majority of EU member states were once invaded and occupied by Nazi Germany or by the Soviet Union, or, for example, in the case of Poland, by both. Now, let me just ask a question here. How many of you in this room are familiar with the provisions of the Lisbon Treaty? Put your hands up. Yeah, put your hands up if you are. Could you put your hands up if you claim to be unfamiliar with the Lisbon Treaty? How much media attention was given to the Lisbon Treaty provisions when the Lisbon Treaty was coming into force late last year? In the UK, most of the attention was on whether Tony Blair would assume the presidency. Was it the same here? I was watching Rick actually on the day that the Lisbon Treaty came into force, and they were more preoccupied with other things. So I'm going to say a few words about the Lisbon Treaty, but it's against that backdrop, against that historical backdrop. Now, what does the Lisbon Treaty do? Well, I'm not an EU lawyer. I teach constitutional law at my university, but I'm not an EU law expert. But as I understand it, what the Lisbon Treaty does is three fundamental things of relevance to Cyprus. It does other things as well, but there are three things it does which I think are of profound relevance to Cyprus. Firstly, the Lisbon Treaty reinforces and to some extent expands the fundamental human rights and freedoms of EU citizens, including the citizens of this republic. Now, the European Convention of Human Rights, remember, is a non-EU treaty. It has non-EU parties such as Turkey and Russia as parties. It's a non-EU treaty. And people confuse the two. The European Convention of Human Rights has given rise to the European Court of Human Rights. The European Court of Human Rights is not an EU court. But over the years, because the EU was established with a human rights ethic, the European Court of Justice, the EU court, has acknowledged human rights law as part of the European heritage. But what the Lisbon Treaty has done is that it has further enshrined, if I can use that phrase, further enshrined the status of fundamental human rights in EU law. And that's of great importance to this island. The Lisbon Treaty envisages the European Union as a separate legal entity in its own right, becoming a party to the European Convention of Human Rights. That's why the Eurosceptics were against Lisbon, because it takes us even further, perhaps, in the federalist direction. But the second thing that it does is that the Lisbon Treaty proclaims the provisions in the European Convention of Human Rights as general principles of EU law. Why is this important? Well, it's important because the provisions of the European Convention of Human Rights are our inheritance. They are the response to what the Germans were doing throughout Europe in the Second World War. Article 2, the right to life. Article 3, the prohibition of torture. Article 14, the prohibition of discrimination. Now, there are a number of qualified rights, I know, but these are of great significance to this island, and they've given rise to litigation such as the Loisido case. The qualified right to private and family life, the home and correspondence, Article 8. The qualified right to property, Article 1 of the first protocol of the Convention. Remember, ladies and gentlemen, none of these human rights were available to the Jews in Germany. And indeed, even if they were available to the Jews in Germany, if a Jew had appeared in a court of law in Germany, the courts were corrupted, and it would have been impossible for these rights to have been enforced. So what the Lisbon Treaty does is it further strengthens human rights in the European Union, at least on a legal basis. What it also does is that it introduces, or brings into force rather, the 2000 Charter of Fundamental Rights of the European Union. Now again, how many hands up if you're familiar with the provisions of this document? Hands up if you're not, be honest. Well, I wasn't until I had a look at it a few weeks ago. It reflects pre-existing human rights and pre-existing rights under EU law. But it goes in some respects a little bit further than the European Convention of Human Rights. I'll just give you an example with reference to the right to property. This is why I was shocked that there was little or no media analysis of this on RIC when I was watching in December. This is what the additional protocol of the European Convention of Human Rights says on the right to property. Every natural or legal person is entitled to the peaceful enjoyment of his possessions. And then there's the qualification which gives politicians wriggle room for qualifying it. But notice, every natural or legal person is entitled to the peaceful enjoyment of his possessions. That's in the European Convention of Human Rights 1950. When you look at the equivalent provision in the Charter of Fundamental Rights at Article 17, you find similar wording, but it's couched in better terms. Everyone has the right to own, use, dispose of, and bequeath his or her lawfully acquired possessions. And then there's the qualification. So the lawyers in this room, have a look at that and explain it to the public. Because if we lawyers don't explain the law to the public, we can't rely on politicians to do so on behalf of the public. The next example I just want to give you very briefly is the prohibition of discrimination, which outlaws, this is already pre-existing EU law, but the Charter reinforces it. It prohibits discrimination on any grounds such as sex, race, colour, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age or sexual orientation. That's quite significant for Cyprus, as indeed it is for every other EU member state. Now, I'm not going to go on any further other than to draw your attention to one other provision in the Charter. It's Article 52, and this allows for politicians to constrict freedom and constrict liberties, but it allows it in certain very limited circumstances. This is what Article 52 says. Any limitation on the exercise of the rights and freedoms recognised by this Charter must be provided by law and must respect the essence of those rights and freedoms. So there are other provisions, but the point is you cannot restrict these rights and freedoms in a manner that violates the essence of these rights and freedoms. Think about that, study the Lisbon Treaty, study the Charter of Fundamental Rights and draw your own conclusions. The third reason why the Lisbon Treaty is so important, so I've already mentioned the European Convention of Human Rights, I've already mentioned the Charter of Fundamental Rights and Freedoms. The third reason why the Lisbon Treaty is so important relates to my theme today, the rule of law. The rule of law has appeared in recent editions of the EU Treaty, which is the overarching treaty governing the EU, and the Lisbon Treaty once again underlines the importance of this constitutional principle. The preamble of the EU Treaty, now that it's been amended by Lisbon, specifies that the rule of law is one of the principles to which EU member states are committed, and it goes on to say that the rule of law is one of the common values upon which the European Union is founded. So the European Union, of which the Republic forms a very small part, is founded on the rule of law. That's a response to Germany under Hitler and the Soviet Union under Lenin, Stalin and Brezhnev. The emphasis on the rule of law in the EU Treaty is likewise reflected in the case law of the European Court of Human Rights. I don't have time to look at this case in any great detail, but I'd like you to draw your attention to the case of Cady. Have any of you heard of the case of Cady? Put your hands up. Fantastic. I'm not an EU law expert, but as I understand it, in this case of Cady, this was relating to the post-9/11 events, UN Security Council resolutions and the introduction by the EU of counter-terrorism measures which allegedly infringed the rights and human rights and the right to property of individuals. The European Court of Justice underlined that, quote, measures incompatible with respect for human rights, including the right to property, are not acceptable in the EU. In Cady, the European Court of Justice, this is the EU court, not the Human Rights Court, the EU court, reiterated that the community is based on the rule of law, inasmuch as neither its member states nor its institutions can avoid the review of the conformity of their acts with the basic constitutional charter, the EC Treaty, which established a complete system of legal remedies and procedures designed to enable the Court of Justice to review the legality of acts of the institutions. Is anybody here scared that one day politicians might come along and strip you of your rights? You put your hands up if you are, and we'd like to put your hand up. Okay? Well, this is your safety net. The European Court of Justice is there to act as the guardian of the rule of law. The judiciary of your member state is the guardian of the rule of law. Your legal profession is the guardian of the rule of law. What this case reiterates is that it is not open for politicians or for EU institutions to violate fundamental rights. Now, the politicians might try and find ingenious ways of violating the human rights and gold-plating the violations in the form of law or legal measures, but it's open to a citizen to challenge the legality of those measures in a court of law. And I had to go one step further. If the court holds that the state is in violation of the law, the state must comply with the court order. And by the same token, if the citizen loses, the citizen must comply with the court order. So the law is no guarantee that you will win. Access to justice does not mean access to victory. It means access to justice according to a court of law. So if you are, I did see one or two hands going up, instruct the lawyers in the room to prepare a case if and when it's necessary to do so. But as we lawyers always say, we don't want to resort to litigation, we want to prevent litigation from happening. So let me just move on and to come to the nub, I'm conscious of the time, let me now come to the nub of my analysis today. What is the rule of law? Politicians quote from it, cite it, UN Secretary Generals refer to it. I noticed a while back that Mr. Barroso came to Cyprus and he said that the Cyprus question must be solved in accordance with the rule of law. Politicians love this phrase. We were in Afghanistan and Iraq to establish the rule of law. But what does it mean? The starting point is that the EU treaty, which refers to the rule of law, gives no definition. The rule of law appears in the document that solicitors are bound by, practicing solicitors, which I'm no longer one. There's no definition in the Code of Conduct for solicitors. It's referred to as a concept in our English Acts of Parliament, the Constitutional Reform Act 2005 and the Legal Services Act 2007, but there's no definition. And one of our great judges in England was a little bit bemused by this. Why does this fundamentally significant phrase appear in all of these treaties and in all of these Acts of Parliament, but nobody has given us a definition? That judge, ladies and gentlemen, is unquestionably the greatest judge of recent years, arguably the most distinguished judge of the past 50 years, and that's Lord Bingham of Cornhill. Now, Lord Bingham has the distinction of holding 3 of the great judicial offices of state in the UK. He's acted as Master of the Rolls, Lord Chief Justice, and Senior Law Lord. He originally analysed the rule of law in a lecture at the University of Cambridge in 2006. The transcript was subsequently published in the form of an article in the Cambridge Law Journal. And a few days ago, quite fortuitously for my visit to Cyprus, he published a book entitled The Rule of Law. Can I ask you if any of you have purchased the book or are aware of its existence? Has it been reported in the Cyprus media? This is the solution of the Cyprus question, the solution of political problems in Afghanistan, Iraq, Egypt, Lebanon, Syria, everywhere in the world is to be found in this book. Now, I'm exaggerating to the extent that I know of the political and practical realities with ensuring that an ideal can be introduced. But if you want a frame of reference, if you want a framework for settling problems on a multi-ethnic basis, here's your framework. It's set out in Lord Bingham's great book. He's written this with the UK primarily in mind, but he has half an eye on the rest of the world as emerges from his book. So I'd encourage everybody to purchase this book. £15 from Amazon, I discovered yesterday, £20 from all good bookshops in the UK. Now, I want to explain to you what Bingham says over the next few minutes. Now, Bingham is aware of the fact that the expression, the rule of law, was reportedly originally coined by Professor Dicey, the great constitutional scholar of the Victorian era in the late 19th century, when he wrote his great book published in 1885. But as Bingham writes, the point is fairly made that even if Dicey coined the expression rule of law, he did not invent the idea behind it. Bingham goes on to say one author, Brian Zamanaha, who wrote a book on the rule of law, has traced the idea back to Aristotle, who in a modern English translation refers to the rule of law, although, Bingham adds, the passage more literally translated says, it is better for the law to rule than any one of its citizens. And Aristotle continues, so even if the guardians of the laws, so even the guardians of the laws are obeying the laws. So it's essential, according to Aristotle, that the guardians of the laws comply with the laws. I mean, that's the essence of the traditional classical conception of the rule of law. Now, Dicey, I'm not going to go into what Dicey said, other than to say, to pinpoint his cardinal principle, nobody is above the law. Bingham looked at Dicey's definition from 1885, I should say Lord Bingham, of course, and realised this is a concept, a definition reflecting 1885. We need a 21st century definition against the backdrop of international terrorism, international warfare, and let me add, politicians who have little or no understanding of the rule of law. That's my way, not Lord Bingham's. And this is Lord Bingham's definition of the core of the rule of law. The core of the rule of law. The core of the existing principle is that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. Now, by way of caveat, Lord Bingham adds that I doubt if anyone would suggest this statement could be applied without exception or qualification, but any departure from the rule, he says, calls for close consideration and clear justification. Lord Bingham reminds us of what John Locke said in 1690, shortly after the English Civil War. Wherever law ends, tyranny begins. Now, what does this all mean in practice? For you, for me, for the man in the street and woman in the street? Well, Lord Bingham gave us a little bit more meat in a lecture he gave at the International Bar Association in Madrid last year. What does the rule of law mean? It means that all, not some or many, or the poor or the weak, but all should be bound by and entitled to the benefit of the law of the land, whether they're private citizens or ministers or officials or prime ministers or presidents or police officers or soldiers or whatever. At the heart of the rule of law, surely, is the principle that the law binds everyone, including the powerful and the mighty. And I would add, this is Lord Bingham, I would add, particularly the powerful and the mighty. So the rule of law operates as a constraint on the exercise of public power and gives effect to the principle enunciated by a curious man called Dr. Thomas Fuller in 1733, "Be you never so high, the law is above you." And that's what I teach my students. Whenever you see a politician grandstanding, remember those words. Be you never so high, the law is above you. Whenever you see kids on the street spraying graffiti on the wall, be you never so high, the law is above you. It's a principle of universal application, whether you're dealing with a prime minister or a teenager spraying graffiti on the street, or a soldier who's manning a ceasefire line. The law is above everyone. I just want to now unpick this phrase with reference to Lord Bingham and one or two other judges. The point about public promulgation, public laws, was picked up by US Supreme Court Justice Anthony Kennedy. He asserted that the rule of, this is the current US Supreme Court Justice Anthony Kennedy, he asserted that the rule of law means that the people have a right to have a voice in the laws that govern them. So there's a process element to the rule of law, Justice Kennedy says. But it isn't just process. Because the right to participate in government is nothing less than the right to shape your own destiny. And I'm troubled by this. I'm just going to move on to the next part of my talk. I'm troubled by this because what are we seeing here in the Republic of Cyprus? We're seeing politicians from the executive branch locked behind closed doors with an Australian diplomat who was involved in the invasion of Iraq. We're following the Annan Plan model. What are they doing? They're drafting constitutional, legislative and other legal instruments which are going to affect your rights as a citizen of the Republic, your rights as a citizen of the Republic, my rights as a UK citizen who may be coming over to this country every now and again. They're sitting behind closed doors in secret, members of the executive branch assuming essentially a legislative function. That's a violation of the separation of powers and the rule of law. It's also, I would add, ladies and gentlemen, inherently dangerous. I'm not comparing politicians here with Hitler and Stalin, but the point remains, Hitler and Stalin legislated in secret. There was no public participation in the drafting of laws by Hitler and Stalin. Everything was done behind closed doors. And I'm troubled here, and I'm going to just give you a lovely quote from one of our ministers in the UK, if I can find it. Yes, here it is. This is Kris Bryant MP, our Minister for Europe in the Foreign Office in the UK, as reported by the Athens News. Lots of people, according to Mr. Bryant, myself included, do not know exactly what has been designed and agreed so far in the talks relating to the Cyprus question. That is a process the UN takes the leaders through. Sometimes the negotiations work better and are most likely to be successful when they are not scrutinised line by the public, by the press, by the media. Mr. Bryant concluded, it's a bit like mushrooms. They grow best in the dark. Well, we know from our expenses scandal in the UK what happens when you allow politicians to fill forms and draft documents behind closed doors without any public access. And it's thanks to New Labour's Freedom of Information Act that we eventually discovered what was going on behind closed doors in Parliament with those forms and those documents that were being drafted behind closed doors without any public participation or sight. And that just leads me to three key points on the rule of law. The first is, and this is a quote about having closed courts rather than closed legislative drafting. It's a quote from Judge Keith of the US Court of Appeals. Democracies die behind closed doors. Remember that. The second quote is from Epictetus, the Stoic philosopher. No greater thing is created suddenly any more than a bunch of grapes or a fig. If you tell me that you desire a fig, I answer you, there must be time. Let it first blossom, then bear fruit, then ripen. And I would add, a fig needs fresh air and sunlight. Now, I'm conscious of the time. I'm going to try and finish within the next 10 minutes, if I may. And I'm going to take you to Lord Bingham's 8 sub-rules, because he realised his definition of the rule of law is generic. It's not... it requires clarification for it to be understood properly. So let's have a look at Lord Bingham's 8 sub-rules, or principles. Sometimes he calls them sub-rules, sometimes he calls them principles. And I think these are of great importance to Cyprus, because you're going to have a settlement, and a constitutional settlement. A constitutional settlement, I would suggest, has to be built around these 8 sub-rules. And if they're not built around these 8 sub-rules, then you're asking for trouble in the form of an absence of the rule of law. So let's have a look at the 8 sub-rules. I'm just going to skate over these. 1, the law must be accessible and, so far as possible, intelligible, clear and predictable. 2, questions of legal right should be resolved by the application of law and not the exercise of discretion. Now, I'm thinking here of the settlers. You know, and I hear in the media what 50,000 are going to stay or 50,000 are going to go. You don't deal with human beings on the basis of discretion. You deal with human beings on the basis of legal principle. And it's clear from the Geneva Conventions that if Turkey has brought any settlers over, then a war crime has been committed. But you don't respond to a war crime by perpetrating another war crime in the form of sending the police round, arresting people who happen to be on a list of names. The settlers, if there are settlers here who need to go, and I believe the settlers should go under any settlement, settlers should be subject to a process involving legal principles. They should be subject to a process involving a due process. They should be given an opportunity to reject or challenge the deportation order, if a deportation order is served on them, and they should have a right to appear in a court of law to defend themselves. And if a court of law decrees that they are in breach of the law and they must go, so be it. But you cannot have a situation where politicians behind closed doors are cooking up deals with numbers. You have to have a legal basis for any settlement. So that's the second point. Thirdly, the laws of the land must apply equally to all, subject to exceptions. So citizens of the Republic should be treated on one basis. Other people should be treated on the same basis unless you can justify the distinction, as in the case of illegal aliens, for example. Fourthly, the law must afford adequate protection of fundamental human rights. 5, access to justice is essential. 6, ministers and public officials at all levels must act reasonably, in good faith, and within the established grounds of judicial review. 7, the adjudicative procedures of the state must be fair. And 8, and this is key, the rule of law requires compliance by the state with its obligations in international law. And in a recent lecture, Lord Phillips of Worth Travers, the senior law lord who succeeded Lord Bingham in the then House of Lords, now Supreme Court of the UK, picked up this theme of compliance with international law. You cannot have the rule of law if the state disregards the rule of law. And Lord Phillips, in a speech in Qatar, I think that's important because our judges in England want the rule of law message to spread beyond the UK and Europe to all corners of the world. Lord Phillips said, there are only 2 ways to resolve the tensions in the world, including those which arise from different religions and ideologies. One is war, and the other is law. This is how important the rule of law is. Without a universal commitment to the ultimate authority of law, law founded on principle and administered through independent, stable and respected judicial systems, the world as we know is not going to survive. Words of Lord Phillips. He advanced 6 propositions. First, this is the president of our new Supreme Court in the UK. First, there must be national respect for the rule of law. Respect for the rule of law has to be learned and earned. Governments must respect the rule of law in their own countries if there is to be any hope that they will respect it in their dealings with each other. I can see some of you scribbling down. My paper will be available as soon as the paper session ends. Second, the commitment to the rule of law must be worldwide. You can't just have the rule of law at home and violate it externally. And our case law in relation to Iraq reinforces that. Thirdly, everyone shares responsibility for maintaining the rule of law. Fourth, the rule of law requires constant vigilance. The rule of law is never negotiable. Not my words, Lord Philip's words. The rule of law is never negotiable. It's not a luxury item that can be put away in the cellar in times of emergency to be brought out again when things get better. It is never negotiable. The fifth proposition is that access to justice must be open to all. You can't have political leaders sitting behind closed doors thinking up of ingenious ways to oust the jurisdiction of the court and to close the opportunity for a citizen of Gerinia, or by the same token, a settler, from going to court. Everybody is entitled to the protection of a court of law, whether it's a Greek Cypriot refugee from Gerinia or a settler from eastern Turkey. The outcome of the court decision may be different in either case, but both of those types of person are entitled to protection under the law. And the sixth and final proposition is that dialogue, understanding and mutual respect are the keys to a rule of law strong enough to withstand the stresses that lie ahead. Now, I'm going to more or less reach my conclusions, but I want you to understand that the rule of law as set out by Lord Bingham, Lord Phillips and Justice Kennedy is an inherently humane rule of law. It's a rule of law that Lord Newburgh, our new Master of the Rolls and Head of Civil Justice, has referred to as the rule of just law. And I think there's a certain resonance there and linguistic logic to it, bearing in mind the Greek language. The rule of just law, which is the phrase used by Lord Newburgh, is in a sense a translation of the Greek phrase grados dikeo, which is the way in which the rule of law is translated into the EU treaty. And also it's the phrase that's used by the Cyprus Supreme Court. So the rule of law, as we understand it in the West, equates to the rule of just law. It's not the rule of arbitrary law. It's not the rule of Stalinist law or Leninist law or Hitlerian law, which is that this is what the law says, you must comply with it. Our law is inherently compassionate, humane, and based upon fundamental human rights and compliance with international law. And the same goes for rights. The Greek word for rights is δικαιοσύνη, which is enveloped within the concept of justice and the rule of just law. And I just think, before I do reach my conclusions, it's important to remind ourselves that the rule of just law is not one and the same thing as the rule of arbitrary law. The rule of arbitrary law is the type of law that was practiced by Hitler's Germany and by the Soviet Union of Lenin and Stalin. And let me read to you Lenin's interpretation of the rule of law. Lenin said the following, and remember, Lenin believed in the dictatorship of the proletariat, the means by which the workers could seize property from the landed class and control society. Lenin believed in, quote, the scientific concept of dictatorship, and this means nothing more nor less than completely unrestricted power, absolutely unimpeded by laws or regulations, and resting directly on the use of force. Now, Lenin wasn't entirely consistent with his views. He did introduce new laws, but they weren't laws in a modern, humane European sense. These were decrees which you had to obey or you were sent to the Gulag. To Lenin, as well as Stalin, the law amounted to a cold, blunt, ruthless instrument to sustain the dictatorship, protect the party, seize property, entrench communism, serve the state, and subjugate the civilian. In other words, the Leninist rule of law was the rule of arbitrary law, or rule by law. That's a philosophical point as well as a legal point, but I want you to grasp it. There's a difference between the rule of just law, as we understand it in the EU, and the rule of law as those with an authoritarian mindset perceive it. And this is the twisted logic, ladies and gentlemen, that gives rise to the state entering into our lives and taking our property. And I want you to just remember those words of Lenin. Now, I have to add here, Lenin was a lawyer by profession, And he was versed in Greek as well as Latin, and he was familiar with the works of Aristotle, who wrote so extensively about law, reason, justice, ethics. But Lenin recoiled from the Greek tradition. He recoiled from the European approach to the rule of law, because as he saw it, the ancient Greek capitalist society was a democracy, and freedom in capitalist society always remains the same as it is in ancient Greek republics, according to Lenin. Freedom for slave owners and anybody else who owns property. So that communist Hitlerian approach to the rule of law is not what we lawyers in the West believe in. We believe in something that's inherently humane. I now, and you'll be pleased to know, reaching my conclusions. And I'm going to make some quick points here before I hand over to Kostas. This book and read it. Lord Bingham, it's only 174 pages. I think Lord Bingham has written it with the layman in mind. He says it in the introduction. This isn't written for us lawyers, it's written for you, for everybody. And I would like to see politicians read that, understand it, and embrace the principles. The next point I want to make in conclusion is that beware of labels. I've said this before in lectures. We lawyers, we look behind the label. We analyse the label, but we look behind the label. We're not tricked by what politicians say and how politicians dazzle us. We want to know what is it that's lurking behind the label. Next point. I quote Abraham Lincoln. Let's have faith that right makes might. Not might makes right, but right makes might. And let us also embrace the words of Lord Atkin, the great English judge, who said that amid the clash of arms, the laws are not silent. That was a riposte to Cicero. This is an ancient question. Do you give in to pressure from outside, or do you stick to your principles? I would take the view, ladies and gentlemen, that you stick to principle. I would take the view that you should resist the temptation to provide legitimisation to war crimes and violations of the rule of law, in the forlorn hope that a surrender of your principles will give rise to temporary peace. History shows that temporary peace doesn't last for very long. And I would also remind you of what Anthony D'Amato said, the great American international lawyer. The question about human rights is not where do they come from, but who is trying to take them away from us. Right, I've spent far too long on the rule of law. My paper will be circulated at the end of the seminar at the end. But I just want you to take these thoughts with you today. Everybody is bound by the law. Everybody is entitled to the protection afforded by the law. In the very worst case scenario, everybody has an opportunity to go to court to protect their rights. Nobody is above the law, however powerful they are. Nobody is beneath the law, however poor or weak they are. And the lawyers in this room, I think, have a sacred duty. They have a sacred duty to uphold this principle. They have a sacred duty to protect the rights of the citizens. And I would call on the lawyers in this room to prepare the ground for litigation, just in case litigation is necessary, in order to challenge whatever may emerge from those mushrooms that are growing in the dark. The final word must be left to Lord Bingham. I have to finish with Lord Bingham, and this is what he says at the conclusion of his great book. What's the difference between good and bad government? I would answer, no doubt predictably, the rule of law. In a world divided by differences of nationality, race, colour, religion and wealth, it's one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion. The rule of law remains an ideal, but an ideal worth striving for, in the interests of good government and peace, at home and in the world at large. Thank you. And the sixth and final proposition is that dialogue, understanding and mutual respect are the keys to a rule of law strong enough to withstand the stresses that lie ahead. Now, I'm going to more or less reach my conclusions, but I want you to understand that the rule of law as set out by Lord Bingham, Lord Phillips and Justice Kennedy is an inherently humane rule of law. It's a rule of law that Lord Neuberger, our new Master of the Rolls and Head of Civil Justice, has referred to as the rule of just law. And I think there's a certain resonance there and linguistic logic to it, bearing in mind the Greek language. The rule of just law, which is the phrase used by Lord Neuberger, is in a sense a translation of the Greek phrase grados dikeo, which is the way in which the rule of law is translated into the EU treaty. And also it's the phrase that's used by the Cyprus Supreme Court. So the rule of law, as we understand it in the West, equates to the rule of just law. It's not the rule of arbitrary law, it's not the rule of Stalinist law or Leninist law or Hitlerian law, which is that this is what the law says, you must comply with it. Our law is inherently compassionate, humane, and based upon fundamental human rights and compliance with international law. And the same goes for rights. The Greek word for rights is δικαιοσύνη, which is enveloped within the concept of justice and the rule of just law. And I just think, before I do reach my conclusions, it's important to remind ourselves that the rule of just law is not one and the same thing as the rule of arbitrary law. The rule of arbitrary law is the type of law that was practiced by Hitler's Germany and by the Soviet Union of Lenin and Stalin. And let me read to you Lenin's interpretation of the rule of law. Lenin said the following, and remember, Lenin believed in the dictatorship of the proletariat, the means by which the workers could seize property from the landed class and control society. Lenin believed in, quote, the scientific concept of dictatorship, and this means nothing more nor less than completely unrestricted power, absolutely unimpeded by laws or regulations, and resting directly on the use of force. Now, Lenin wasn't entirely consistent with his views. He did introduce new laws, but they weren't laws in a modern, humane European sense. These were decrees which you had to obey or you were sent to the Gulag. To Lenin, as well as Stalin, the law amounted to a cold, blunt, ruthless instrument to sustain the dictatorship, protect the party, seize property, entrench communism, serve the state, and subjugate the civilian. In other words, the Leninist rule of law was the rule of arbitrary law, or rule by law. That's a philosophical point as well as a legal point, but I want you to grasp it. There's a difference between the rule of just law, as we understand it in the EU, and the rule of law as those with an authoritarian mindset perceive it. And this is the twisted logic, ladies and gentlemen, that gives rise to the state entering into our lives and taking our property. And I want you to just remember those words of Lenin. Now, I have to add here, Lenin was a lawyer by profession, and he was versed in Greek as well as Latin, and he was familiar with the works of Aristotle, who wrote so extensively about law, reason, justice, ethics. But Lenin recoiled from the Greek tradition. He recoiled from the European approach to the rule of law, because as he saw it, the ancient Greek capitalist society was a democracy, and freedom in capitalist society always remains the same as it is in ancient Greek republics, according to Lenin. Freedom for slave owners and anybody else who owns property. So that communist Hitlerian approach to the rule of law is not what we lawyers in the West believe in. We believe in something that's inherently humane. I now, and you'll be pleased to know, reaching my conclusions. And I'm going to make some quick points here before I hand over to Gustas. This book and read it. Lord Bingham, it's only 174 pages. I think Lord Bingham has written it with the layman in mind. He says it in the introduction. This isn't written for us lawyers, it's written for you, for everybody. And I would like to see politicians read that, understand it, and embrace the principles. The next point I want to make in conclusion is that beware of labels. I've said this before in lectures. We lawyers, we look behind the label. We analyse the label, but we look behind the label. We're not tricked by what politicians say and how politicians dazzle us. We want to know what is it that's lurking behind the label. Next point. I quote Abraham Lincoln. Let's have faith that right makes might. Not might makes right, but right makes might. And let us also embrace the words of Lord Atkin, the great English judge, who said that amid the clash of arms, the laws are not silent. That was a riposte to Cicero. This is an ancient question. Do you give in to pressure from outside, or do you stick to your principles? I would take the view, ladies and gentlemen, that you stick to principle. I would take the view that you should resist the temptation to provide legitimisation to war crimes and violations of the rule of law, in the forlorn hope that a surrender of your principles will give rise to temporary peace. History shows that temporary peace doesn't last for very long. And I would also remind you of what Anthony D'Amato said, the great American international lawyer. The question about human rights is not where do they come from, but who is trying to take them away from us. Right, I've spent far too long on the rule of law. My paper will be circulated at the end of the seminar at the end. But I just want you to take these thoughts with you today. Everybody is bound by the law. Everybody is entitled to the protection afforded by the law. In the very worst case scenario, everybody has an opportunity to go to court to protect their rights. Nobody is above the law, however powerful they are. Nobody is beneath the law, however poor or weak they are. And the lawyers in this room, I think, have a sacred duty. They have a sacred duty to uphold this principle. They have a sacred duty to protect the rights of the citizens. And I would call on the lawyers in this room to prepare the ground for litigation, just in case litigation is necessary, in order to challenge whatever may emerge from those mushrooms that are growing in the dark. The final word must be left to Lord Bingham. I have to finish with Lord Bingham, and this is what he says at the conclusion of his great book. What's the difference between good and bad government? I would answer, no doubt predictably, the rule of law. In a world divided by differences of nationality, race, colour, religion, and wealth, it's one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion. The rule of law remains an ideal, but an ideal worth striving for, in the interests of good government and peace, at home and in the world at large. Thank you.